Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about publication bans in sexual assault trials. Cases that should have gone to the Supreme Court of Canada, but didn't. In sexual assault trials, as well as in many other types of trials, there are publication bans that either are required to be ordered or may be ordered. And publication bans are typically used in sexual assault trials to protect the identity of the person who is making the allegation or the alleged victim, as well as potentially to protect the identity of the accused if the relationship between the two of them could have the potential of revealing the identity of the victim. But when cases go to the appellate level courts, these publication bans don't automatically apply in the same way that they do in trial courts, and courts of appeal have to make determinations about whether and when to impose publication bans. This can lead to people who are accused of sexual assault being identified where they otherwise wouldn't be identified. It would never lead to a situation where a complainant, however, would be identified. And this is the issue that was raised in a case called Rhyr before the Ontario Court of Appeal, whether or not a publication ban that was ordered at the lower court level should continue through the appellate proceedings. And when publication bans also cover a significant amount of evidence that's going to be heard, especially in things that could potentially be jury trials, should decisions of the Court of Appeal be shielded or heard in secret because of these publication bans? The open court principle is a very important principle in Canadian law. We have an open court principle because we want people to know and understand the law and see the way that it works. Justice must be seen to be done. But if we have too much of an open court principle, it runs the contrary risk of discouraging people who are victims of sexual assault from reporting and coming forward. It allows those people to be subjected to other types of trauma where potentially their identity could be determined by their connection to the person who is allegedly their assailant. And so in these circumstances, these important balances have never really been considered fully by the Supreme Court of Canada since we've developed a more nuanced understanding of doing trauma-informed practice and trauma-informed court proceedings around victims of sexual assault. It would be nice to see the Supreme Court of Canada revisit the issue of publication bans from a trauma-informed lens, and especially in light of new provisions of the criminal code that also apply to curtail, arguably, the fairness of some sexual assault trials, whether it's for the accused or for the complainant. Unfortunately, the Supreme Court of Canada didn't really see the opportunity here to get in on an issue that could actually have broader implications, not for the law, but for society generally, and for assurances that people who are victims of sexual assault can have their anonymity protected if they come forward. Hopefully the Supreme Court of Canada reconsiders hearing cases on publication bans in sexual assault cases when cases go to the higher court levels, but until then, we're stuck with the law as it currently exists. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.